Chrissy, I was met with a client this morning whose dad died in 2016. We're talking 8 years
Oh my
ago.
goodness.
And dad died with a living trust, and my client's siblings were the successor trustees 8 years later.
It's still going on?
Well, when you do a trust administration, the Florida statutes requires some things of the successor trustees. So my client's brother and sister, number one, it requires them to give a acceptance of trustee. That's it's a sign. It's a form that's signed and sent to all the beneficiaries, where you officially say, "Okay, I agree to be trustee." It requires an inventory. It requires an accounting. My guy's got none of that. None of that. 8 years later.
Oh my gosh.
And he's asking me what to do. And so what I did for
Oh my
him,
gosh.
and by the way, I said, is your brother or sister, are they represented by an attorney? No, but they have an accountant helping them. So really the best that I could do for the client is I pulled out a Word document because he doesn't email, and I typed up, here's a list of 6 questions that you need to ask your brother, your successor trustee, things you need to know. You need an inventory. You need an accounting. You need a proposed plan of distribution about how they intend to divide up the money. And otherwise, we're just guessing at what's going on out there. The reason I bring that up is that we're all about helping people to avoid probate.
Exactly.
And living trusts are all about avoiding probate, but sometimes they can backfire.
Correct.
When you got a successor trustee that 8 years later they're still trying to figure it out, that's not been a success.
No, it
Yeah,
hasn't.
maybe they've avoided probate, but there's been a huge expense to the beneficiaries of this trust.
Correct.
And by the way, in this, I saw the trust, and in here the dad had left everything to the 5 children per stirpes. Per stirpes means one of the kids passes away, and
Goes to
his
their
share
children.
goes to their children. He goes, well, my brother's saying no, that the deceased brother's share is not going to his kids, is not going to the grandkids of our trust maker. We're going to split it up 4 ways. And I go, well, that's not the way the trust reads. And he goes, well, that's what they're going to do. And I said, well, it's no skin off your nose, but when these children of the deceased child someday find out that they should have gotten a 5th and they got nothing, then they're going to be suing your brother, successor trustee, for doing it that way.
Well, that also confirms that brother doesn't have an attorney.
Exactly, yeah. So just, kind of a lesson to be learned there. When we talk about avoiding probate, sometimes one of the good things about the probate is that when probate is required, you've got a probate judge looking over the shoulder of the executor personal representative to make things sure things are done on a timely basis and in an honest basis.
Correct. You are right.
In a trust administration, there's nobody looking over the shoulder of the trustee to make sure things are done timely and honestly.
So you make a great point that even though we're all about avoiding probate, sometimes the process of probate is good because you do have a judge looking over it. Interestingly enough, on the trust administration side and on a trust, it would require each beneficiary to hire and pay an attorney because there is no judge looking over it
Exactly.
if they needed to pursue it.
Yeah.